Hello, Judge.
Yes,
Can you hear me well?
yes, we can. Also, Montgomery, you have a question?
No, man. I'll just make sure I can be heard to keep Queen cases coming up.
Okay, so I'm going to put you on mute. We're going to start the next hearing. Thank you. Good afternoon, everyone. My name is Judge Tamika West Bernard. I'm presiding over the preliminary hearing calendar for today. The next case on the calendar is the State of Georgia versus Keith M. Queen for warrant number 2022 CW 55496 for the charge of murder. Second charge, warrant number 2022 CW 55497 for the charge of aggravated assault. Third warrant is 2022 CW 55498 for the charge of tampering with evidence, felony. Fifth charge, warrant number 2022 CW 55499, another count of murder. So those are the charges pending against Mr. Queen today. Is the state ready to proceed?
Yes, Judge, and the state calls Detective Montgomery.
Okay.
Yes, sir.
Detective, can you raise your right hand? You swear or affirm testimony you'll give this matter pending before the court is truth, whole truth, nothing but truth, so help you God.
I do.
Lower your hand and introduce yourself to the court.
My name is Detective Montgomery. I've been employed with the Clayton County Police since 2013. I became a detective in 2018.
Okay. And Detective Montgomery, in your role as a detective, did you investigate a shooting that occurred on December 8th of 2022?
Yes, sir.
Okay. And this, it's my understanding this there's a couple different incident locations here, but did you yourself go out to 6668 Mount Zion Boulevard?
Yes, sir. I went to both incident locations.
Okay, so let's start with the 6668 Mount Zion Boulevard location.
For the purpose of this testimony, I'm gonna be referring to the people by name since most of the people died. I was notified by a lieutenant of a double homicide that occurred minutes apart at locations that was less than a mile apart. He believed that they might be related. Detective Rowland responded to 668 Mount Zion Boulevard, which is Panther Creek Apartments, and I responded to 6659 London Dairy Drive. Upon arrival to that location, I made contact with Kayla Carter. Ms. Carter stated that she was at the residence with Juan Montalvo and Keith Queen Jr., and they left the residence around 11:30ish to go to the store. She stated about 7 minutes later, she heard gunshots, and she became worried for Mr. Queen and Mr. Montalvo, who was her boyfriend. Let me also state that when they left the residence, that Mr. Montalvo was driving her vehicle and Mr. Queen was the passenger. She stated she tried to call them, nobody picked up, so she began worried. And she said moments later they arrived at her residence in her vehicle, which is a tan SUV Tahoe. She said Mr. Queen was now driving at this time, and he pulled Mr. Montalvo out of the passenger side of the vehicle and laid him on the ground. He said help. He was advised to help him. And she stated that Mr. Queen left in a panic in her vehicle.
Okay, so you spoke to Miss Carter, and what was her relation to Keith Queen?
That is her son.
Okay, and you said the deceased Mr. Montalvo was her boyfriend?
Yes.
Okay. And you said that the 6668 Mount Zion Boulevard, that's approximately about a mile from her residence?
A mile or so, yes, sir.
And Mr. Queen and Mr. Montalvo had driven her tan SUV?
Yes, sir.
Regarding did Miss Carter provide you with any information about kind of the circumstances around Mr. Montalvo's shooting? Was she aware
No,
of any other information?
no, sir. She just said that they were supposed to be going to the store. She heard multiple shots. And when he returned, when him and Mr. Queen returned to the residence, he was shot and bleeding.
Okay. So did you then go to 6668 Mount Zion Boulevard, or was that the other detective solely who kind of handled that incident?
He went over there initially. If I could kind of tell how things progressed linearly, from my perspective, I'll go ahead. So I stayed with Miss Carter, and we was looking for trying to get Mr. Queen to return to the residence in a tan SUV because of the circumstances of the shooting that had occurred. I eventually got to speak to Mr. Queen on the phone. He said that he was in a panic, like she said, and that he would be returning at some point. His tag was put on the flock system, and it was shown that he had drove south to Henry County, and a bowler was put out for the vehicle. At some point, I was contacted by Henry County Police. Sergeant Clayton from Henry County Police stated that she observed the vehicle at 390 Navarro Road, which is located in Henry County, Locust Grove. She stated that it was parked. Eventually, they made contact with Mr. Queen, who appeared to be cleaning out the vehicle. He had cleaning products in the vehicle as well, I believe, in his hand. He was taken into custody and brought back to Clayton County. I responded to 6668 Mount Zion Boulevard, and I made the contact with Detective Rowland, who was the lead on this investigation. At that location, I observed Zachary Talent, who was the other victim, was on the floor. He was deceased with apparently one bullet to the head. His girlfriend informed us that he was supposed to be coming to meet somebody, but she was unaware of who he was supposed to meet, possibly Alex. And then you can go further if you want to go further with any questions.
Okay, so yeah, I think that's a good point to kind of start breaking things down. So you learned that Mr. Queen fled to the Locust Grove area?
Yes, sir, through the flock system and him being his vehicle being identified by a Henry County police officer.
Okay, and you said the Henry County officers, when they made contact with him, observed that he had cleaning products in his hand?
Yes, sir. I believe it was located in the vehicle as well.
Okay, and that was the same vehicle that Miss Carter observed Mr. Queen drive to her residence or from her residence with?
That was her tan Tahoe.
Okay. Did Henry County officers conduct any further investigation at the Henry County location?
Clayton County responded to that location and kind of took over the scene. We made contact with the residents of that location. They advised that he had arrived and was attempting to get assistance in cleaning out the vehicle. And we got consent to search their residence and recovered shell casings from the trash can that were in a Chick-fil-A box.
Okay, so you recovered some spent shell casings inside the
Yes,
residence?
sir. Spent shell casing.
And did you recover any other rounds or anything from inside of the Tahoe?
A search warrant was obtained. The Tahoe was brought back to Clayton County as well. A search warrant was obtained and spent shell casings were recovered. I don't have I can look at the inventory sheet to tell you exactly everything else. If you want me to.
That's fine, as long as you recall that there were just some spent shell casings recovered from inside the Tahoe.
It was live rounds, a live magazine, long, like for AR style magazine was also recovered. Yes, and spent casings as well.
Okay. Did you, in Henry County or in the Tahoe, were you ever able to locate a firearm?
Negative.
Okay. So turning now to 6668 Mount Zion Boulevard, what is that location?
That is a apartment complex. And to go further into Detective Rowland's investigation, while he was there, he made contact with the witness, William Cox, who advised he observed a black Tahoe arrive and a tan Tahoe arrive, parked next to each other back then. He said he observed, he heard gunfire, and then he observed a male pull out occupant from the back of the tan Tahoe as the black Tahoe sped away. And he observed the male pushing the slumped over front seat driver passenger into the passenger front seat and saying, he advised, I'm gonna get you up, I'm gonna get you help.
Okay, so Mr. Cox was a independent witness who was at the 6668 Mount Zion Boulevard location.
Yes, he just happened to be in his car.
And you were talking about an individual pushing another individual to the passenger seat. Was that with the tan Tahoe or with the black Tahoe?
That's with the tan Tahoe. He said the black Tahoe had already pulled away when he observed the white, the male pull out somebody from the back passenger seat, place him on the floor, and go to the front driver's seat and push that person over to the passenger side.
Okay. During the course of your investigation, did you speak further with Mr. Cox in terms of if he was able to identify any of the individuals who you ultimately arrested?
I did not speak further to him at all.
Okay.
But from his statement, it was just, he said a male. It didn't appear that he was able to identify.
Okay. And Mr. Talent, the victim, Mr. Talon, he was on scene when you arrived?
He was deceased. Yes, sir. He was still on the ground.
Okay, he had already been pronounced deceased at that time?
Not the ME hadn't showed up when I was over there, but yes, he was on the ground.
Okay.
And motionless, if you want to say.
And Mr. Montalvo, when you arrived to the original location you're at on Londonderry, was he deceased at that time? Or was he transported?
He was pronounced deceased when I was there. Initially, it appeared that he had been shot in the chest because he was laying on his back still. After the ME arrived and processed the scene, he was flipped over and we observed three gunshot holes and wounds to his black shirt and back.
Okay. And now let's talk about, did you speak with an individual named Dickens?
Yes, sir. So as the night went on, we inventoried the vehicle and things of that nature. Mr. Queen declined to speak to us. An individual named Charles, let me make sure I get the right name right. I believe it was Charles Dickens. Chase Dickens. The individual named Chase Dickens contacted the police and said he was involved in the shooting tonight. He wanted to speak with officers. He was brought to the location by a guardian, and he was interviewed by myself and Detective Roller.
Okay. And what did Mr. Dickens provide you in terms of a situation? And let me strike that and ask you a question first. You indicated Mr. Dickens came with a guardian. How old approximately is Mr. Dickens? Was he an adult or?
Mr. Dickens was 14 years old.
Okay. So he was a juvenile?
Yes, sir.
Okay. What did Mr. Dickens indicate to you?
Mr. Dickens stated on the night of the incident, he was riding with Mr. Talent as a passenger. He was just riding alone as somebody that he's very cool with. He had been staying with them for a week or so. He advised that Mr. Talent advised him to ride with him. They went to the Quick Trip to meet somebody. He said a vehicle, he described it as a Gold Explorer, came to the Quick Trip, and Mr. Talent received a call, and they followed that vehicle to the apartment complex. He said once they arrived at the apartment complex, which I believe to be 668 Mount Zion Boulevard, he said once they arrived at the location, they backed in. The black Tahoe and the gold SUV backed in next to each other. He said Mr. Talent exited the driver's side of the vehicle and got into the rear vehicle, the gold SUV. He said they were talking for a while and appeared to be opening a bag or something in that nature. He advised the passenger of that vehicle, who was a white male with a gray hoodie and curly hair, exited to the back seat of the vehicle, opened the door. He advised the driver of that vehicle raised a large gun. He describes this large gun, possibly a rifle, and pointed it at Mr. Talent in the back seat. And the white male who was on the outside of the vehicle after opening the door also pointed a gun at Mr. Talent. Mr. Dickens advised that Mr. Talent always has a gun on his person and also has a gun in the vehicle. He said upon seeing his friend being threatened with deadly force, he reached for the revolver that was in the vehicle with him. He advised the white male that was on the outside of the SUV began to fire at Mr. Talent. And then he said, as a result of him firing at Mr. Talent, he began to fire at the driver of the gold SUV, whom he described in description as Mr. Montalvo.
Okay, so let me break that down a little bit. Mr. Dickens was acquaintances with the victim, Mr. Talent.
Yes, sir.
Okay, and they were meeting up with some individuals in a gold SUV.
Yes.
Okay. Did his description of that gold SUV fit the Tahoe that Mr. Queen was driving?
Not to extent, because he called it a gold Ford Explorer, our Expedition.
Okay.
But it was a gold SUV.
Okay. And Mr. Mr. Dickens stayed in the black SUV while Mr. Talent went into the gold SUV?
Yes, sir. He was in the front passenger seat the entirety of Mr. Talent exiting the vehicle in the incident in the shooting occurred.
And Mr. Dickens described a white male who he saw shoot at Mr. Talent.
Yes, sir.
The white male had a gray sweatshirt on.
Yes, sir.
When
I think he said gray hoodie to be exact, not a crew sweater or anything like that.
Yes. When Mr. Queen was arrested in Henry County, did you or Henry County locate any articles of clothing?
Yes, sir. I can't remember the color of his pants. He had on white Air Force Ones and a white T-shirt underneath and a gray hoodie.
Okay, gray hoodie. Was there anything on that gray hoodie?
It was pink insignia. Purple insignia, I believe. Mr. Dickens described it as red insignia, some kind of red design.
Okay. Was there any blood on the hoodie?
I can't recall.
Okay. And so Mr. Dickens indicated when he saw the white individual pointing a gun at his friend, he then started shooting at the other individual in the gold car.
Yes, sir. He advised that the driver, who was also pointing a rifle at Mr. Talent, was the person he had the best visual of. He advised that he know that it was the white male shooting because he could see the front driver, that he wasn't shooting in the sound of the gun, wasn't a large gun sound. So he advised he shot at that male instead of shooting at the white male.
Okay. Through your investigation, did you discover or come across any evidence as to what the purpose of the whole meetup was?
After the fact, I did. Speaking to his girlfriend, his girlfriend, Miss Courtney, where the mother's child, Mr. Courtney, she had advised that he was going to purchase some drugs, Mr. Zachary Talent. Mr. Dickens advised he had no knowledge of that. He was just riding with a friend. But Mr. Zachary Talent was supposed to be going to get some drugs fronted to him, like not purchased, but fronted to him off of good faith to either work it off. Okay.
So based on your investigation, do you believe that this was a kind of drug deal gone bad?
If I go further in my investigation, as I got my probable cause, that's what I believe. But going further into the investigation, it led into other things.
Okay. And one second, Judge. Want to make sure I have everything covered. The Detective Montgomery, did you ever speak with Mr. Queen, or I think you indicated that he elected not to speak with you?
Yes, sir. He elected not to speak with me at that time.
Okay. Do you recognize the individual who you know to be Mr. Keith Queen here today or present here today?
Yes, sir.
Can you identify him by an article of clothing and what his Zoom video says?
Says Clayton County juvenile is cut off, but he has a black shirt on.
Okay, let the record reflect that Detective Montgomery has identified the defendant. Detective Montgomery, the 6668 Mount Zion Boulevard location, is that within Clayton County?
Yes, sir.
Okay. No further questions at this time, Judge.
Okay, Attorney Florio, your witness.
Thank you. Detective Montgomery, I understood you to just testify that you initially believed that this was a drug deal gone bad, but that it led into other things. Is that correct?
Yes, sir.
Okay, what are the other things which you referenced on direct?
So after the probable cause was initiated, typed my probable cause, got my warrant. The next day or so, I took time to listen to Mr. Queen. He was in the room with his mother, I believe. Just conversations that they were saying from his point of view. He was saying that Mr. Juan Montalvo said that it was a robbery, basically. He was saying when the person got in the car, Montalvo put him at gunpoint and said, "Give it up, give it up." He said at that point, Mr. Talent reached for his firearm, which is when Mr. Montalvo shot him during the process. He also, during the investigation, looking at Facebook records and messages between the two and other individuals, Mr. Montalvo's Facebook revealed that it appeared he never intended to sell him drugs, that it was going to be a setup for murder the whole time.
Okay, and so just to go back, that was on Mr. Montalvo's personal Facebook page?
Facebook messages, yes, sir.
Okay, and who was he messaging? Who was Mr. Montalvo messaging?
When they showed the intent of a premeditated murder or setup?
Yeah. Yes, sir.
It was a female named Barbie Rodriguez, I believe. I had to look at my notes if you want me to give you the exact Facebook name.
Yes, sir, if you could, please.
All right.
Thank you.
Yes, Barbie Rodriguez.
Okay. And were you able to determine who Ms. Rodriguez? Well, I presume is that a female?
The pictures were of a female. I haven't identified her.
Okay. All right. So during the course of your investigation, you've not spoken with Ms. Rodriguez or anything like that?
No, sir. Just the messages he sent to her.
And what were those messages? What do those messages say, Detective?
Sorry, hold on a second. He said, should I pop Zach? He said, should I pop Zach? And she was like, who? He's like the cousin of Larry. And then I believe she asked why, something of that nature. He was basically I don't have the verbatim, but he was referring to being tried by a male named Larry who had already fronted for drugs. And Mr. Talent was a friend, associate, or fake cousin of Larry. So he felt tried by Larry and was referring to her, I should pop him. I already let somebody else get away with this. But she said, no, you shouldn't do it. He was like, I think I'm still going to pop him.
And so you had a conversation with a young man named Chase Dickens, correct?
Yes, sir.
And Chase told you that they were going there because Mr. Montalvo was going to front drugs to Mr. Talent. Is that correct?
No, sir. Chase did not say that. His mother of his child said that. Mr. Courtney said that. Chase said he was just riding with Mr. Talent.
Gotcha. So the mother of Mr. Talent's child told you that Mr. Talent was going there because Mr. Montalvo was going to front drugs to Mr. Talent. Is that correct?
Yes, that was to the best of her knowledge.
Okay. And do you are you informed or educated as to what the term front means, what it means to front someone drugs?
Well, like I said, reading from the text verbatim, he was saying that give him drugs without having to pay for it, and
Right.
he'll work it off. Yes, sir.
Okay. And so it was the expectation. I understand what those Facebook messages say, but you'd agree with me that it was the expectation per Mr. Talent that he was going to go there and be given drugs for free. Is that correct?
For free, yes, sir.
Okay. And so Mr. Talent, based upon your investigation, he did not have an expectation that he was going to give drugs to Mr. Montalvo. Is that correct?
That he was going to give drugs to Mr. Montalvo?
Right.
No, that he was going to receive drugs, sir.
That's right. And it was
Yes,
not
sir.
Mr. Talent's expectation that he was going to give Mr. Montalvo cash or United States currency to purchase drugs. Is that correct?
No currency was supposed to be given.
Okay. And so irrespective of the Facebook messages, you'd agree with me that there's nothing about this transaction that would have indicated that Mr. Montalvo was going to rob Mr. Talent, because Mr. Talent was not expected to have drugs and Mr. Talent was not expected to have United States currency. Is that correct?
He was not expected. You can't say whether somebody is expected to have money on them at all, but he wasn't supposed to have that amount of money to buy whatever drugs he was getting.
Okay. And so there was nothing in the exchange between Mr. Talent and Mr. Montalvo where Mr. Montalvo was encouraging Mr. Talent to bring a large sum or any money to this transaction. Is that correct?
No, sir.
Okay. And there's nothing about the exchange between Mr. Montalvo and Mr. Talent where Mr. Montalvo was encouraging Mr. Talent to bring narcotics to this transaction. Is that correct?
No, sir.
Okay. And so this idea that, well, there's Facebook messages where Montalvo said he was going to rob Talent, that's contradictory to the actual communication between Montalvo and Talent. Is that correct?
No, sir. The Facebook messages wasn't to him. It was to a female, and it wasn't to rob. It was to kill him, to pop him, in his own words.
All right. And so I understood you to say that at some point there was an idea that these two parties, these two SUVs were going to meet up at the Quick Trip. Is that correct?
That's where Mr. Talent was waiting for him at. Yes, sir.
Okay. And have you been able to determine who communicated with who first? Did Mr. Talent reach out to Mr. Montalvo about this exchange, or did Mr. Montalvo reach out to Mr. Talent about this exchange?
I couldn't tell you. Going back to the text messages, I believe that Mr. Talent reached out to him first. But
Okay.
I don't want to say factually that.
Okay. And so Mr. Talent is the one that reaches out to Montalvo. Who picked the Quick Trip as being the place that they were going to meet?
I believe, let me see. I gotta look to make sure. I might not have it in my notes.
Yes, sir.
But I'll check.
Thank you.
It's not in my notes as far as who actually picked that location. I just know that Mr. Talent was waiting there for about an hour for him.
Okay. And at some point, Mr. Montalvo, I guess, arrived at that location. Is that correct?
Yes, sir. Reviewing Quick Trip footage, he arrived and just circled out and then left, and then the black SUV followed behind him.
Okay. During the course of your investigation, have you been able to determine whether Keith Queen was in communication with Mr. Talent?
Mr. Who? Talent? No, I didn't see any communication between those two.
Okay.
I'm not
And
even aware if he knew who that was.
I was just going to ask anything about your investigation that indicates that Mr. Keith Queen even knew Mr. Talent.
No, Mr. Queen's involvement, as far as I know, is just from knowing Montalvo and everything he deal with.
Okay. And so I understood you to say that Mr. Talent followed Mr. Montalvo to a secondary location, and that was that apartment complex right down the street. Is that correct?
Yes, sir.
Okay. And do you know which car backed in first? It would seem the reason that the Montalvo SUV backed in first. Is that correct, or do you know?
It would seem, but I couldn't be factual on that.
Okay. And you'd agree with me that the Talent SUV, the one that Mr. Talent was driving, it was parked directly next to the parking spot where Mr. Montalvo was. Is that correct?
Yes.
Okay. And you'd agree with me at some point, Mr. Talent got out of his SUV and got into the Montalvo SUV. Is that correct?
Into the back seat. Yes, sir.
Okay. And the reason you know that is because Chase Dickens told you that. Is that correct?
And also the independent witness advising that the body was dragged and placed onto the ground, which the body that was left behind was Mr. Talent. So I would believe that.
Did the independent witness tell you that that Mr. Talent's body was removed from the SUV and pulled into the parking lot? Is that what he said?
Pulled out of the vehicle and placed on the ground, on the pavement.
Okay. The independent witness, at what point did he tell you that he began, or let me ask you this much, who did the independent witness speak with? Was it you or Detective Rowland?
It was Detective Rowland.
Okay. And when the independent witness spoke with Detective Rowland, did the independent witness tell Detective Rowland when his attention was drawn to the two SUVs?
I don't believe so. I could just go by the written statement. I haven't verbally spoken to him.
Okay. And I understood you to say in your direct that he looked at the SUVs when he heard what he believed to be gunshots. Is that correct?
Yes.
Okay. And so prior to there being gunshots or him having heard gunshots, he did not tell you anything about these SUVs. Is that, or Detective Rowling, anything about these SUVs?
I couldn't say because everything is coming secondhand. I can just go by the written statement. But I know at some point in time he looked at the vehicles.
Okay. And at some point, I understand that there was an exchange of gunfire. Is that correct?
Yes, sir.
Okay. And the independent witness, the gentleman that was in the parking lot, his name, Mr. Cox. Mr. Cox did not identify seeing someone shoot a firearm. Is that correct?
Like I said, I'm unaware. I just know he said he seen the shooting. I don't know if he said, like, I actually seen this person shooting.
Okay. The only reason that you believe that Keith Queen fired a gun is because Chase Dickens told you that he fired a gun. Is that correct?
No, sir. Just the totality of everything. Him returning in the vehicle, him being a white male who Mr. Dickens doesn't even know, and identifying the white male shooting. He had no prior knowledge of Mr. Queen to say that this person did this thing.
So you'd agree with me that Mr. Montalvo was shot 3 times in the back, correct?
Yes, sir.
And you'd agree with me that during the course of your investigation, you've determined that Chase Dickens shot Mr. Montalvo 3 times in the back. Is that correct?
I believe he did.
Yeah.
The autopsy and things of that nature have been performed to say so that occurred. But yes, sir, I do believe he did.
Okay. And so let me ask you this much. What proof do you have that Mr. Queen shot Mr. Talent prior to Mr. Dickens shooting Mr. Montalvo?
You talking about the sequence of events?
Absolutely.
No, sir, I have none.
The only reason you believe that Keith shot Talent first is because Dickens told you that. Isn't that correct?
All of this testimony lined up with the evidence that we had in hand. As far as him even saying that the male was turned back with a large rifle, with the large rifle magazine being discovered in the vehicle, with him being shot in the back, with Mr. Queen, with extra shell casings from the vehicle being located, with Mr. Queen discarding of evidence, with all the shell casings that still remained, with all the blood. The behavior of Mr. Queen lended him towards being the person that may have shot first or may have been in that process.
Okay. Were you previously familiar with Chase Dickens or with Chase Dickens? Let me ask you that.
Familiar as far as
Police criminal investigations?
No, sir.
Okay. And you said that there was a guardian that brought him to give this statement. Who was
Yes,
that
sir.
guardian? Who brought him to give this statement?
Richard Brackett.
Richard Brackett. Are you familiar with criminal activity regarding Mr. Brackett?
I'm familiar with him. I believe his daughter got hit, or somebody got hit by a dirt bike. I'm not familiar with him.
Okay. Have you continued after this to monitor Mr. Chase Dickens' social media accounts?
No, sir. I haven't even located Mr. Dickens' social media accounts.
Okay, so Mr. Dickens has not made you aware that he continues to post about this on social media. Is that correct?
No, sir.
Okay. And it seems to reason because of that you've not reviewed Mr. Dickens' social media accounts as recently as yesterday. Is that correct?
Yeah, I haven't seen it all yesterday or the day before.
Okay. Independent of, so we agree, or you believe, based upon your investigation, that Chase Dickens shot Mr. Montalvo 3 times in the back. Is that correct?
Yes, sir.
Okay. And nothing in your investigation would lend you to believe that Mr. Queen shot Mr. Montalvo. Is that correct?
Mr. Montalvo, no, sir.
Okay. It's your belief that Mr. Queen shot Mr. Dickens, Mr. Talent one time in the head. Is that correct?
Mr. Dickens, as well as the vehicle that Mr. Talent, as well as the vehicle that Mr. Dickens was operating.
Okay. And the reason why you believe that Keith shot Mr. Talent is because Mr. Dickens told you that. Is that correct?
As well as the evidence, like I said, the shell casings and things of that nature.
We agree that someone got shot, but the sequence in which it occurred is based solely off of what Dickens told you. Is that correct?
No, the first question you asked me was, do I believe he shot him only based on Mr. Dickens' testimony? And I was just advising, not only on that testimony, based on the shell cases and things of that nature as well. But the sequence, yes, sir, that is based on Mr. Dickens' testimony.
Okay, thank you. I appreciate you agreeing with me on that. Just 1 second, please, Your Honor.
Okay.
All right, no further questions, Your Honor.
Okay, any redirect for the state?
Very briefly, Judge. Detective Montgomery, this may be a question you don't have the answer to, but do you recall what caliber the shell casings that you located inside the vehicle were?
I located, it was 380 shell cases in the vehicle. 380 shell cases were located as well in Locust Grove. And also additional day when I had to go back, I located a 380 shell casing on the floor. I believe it was either a live 40 round in the vehicle. I don't believe it was spent. But like I said, I could look at the inventory sheet and tell you exactly.
Okay, so to your knowledge, 380 caliber shell casings were located inside of the vehicle?
And as well as outside, yes, sir.
Okay, and on the 380, was that the same caliber or a different caliber from what the rifle magazine had loaded into it?
It was a different caliber. It was also a different caliber from the gun that Mr. Talent was known to carry.
Okay, what caliber gun was Mr. Talent known to carry?
And if I'm not mistaken, it was a 4.5. It was a Glock 23, 4.5, something of that nature.
And then Mr. Dickens, who is in the black SUV, did he have a revolver?
That's what he testified to having. And
Okay.
he said he spent the whole cycle shooting. So he probably shot about 5 or 6 shots.
Okay. Did you locate any shell cases inside of the Tahoe, the black Tahoe, I should say?
No, sir.
Okay. With a revolver, would you expect there to be shell casings?
No, sir.
But you didn't locate any firearms from any of the individuals?
No, sir. That leans into the tampering with evidence case. There was tangible evidence that we believe was in the vehicle that Mr. Queen decided to drive down to Henry County with.
Okay. No further questions at this time, Judge.
Okay, Attorney Flora, do you have any questions limited to the scope of the redirect?
I do. Did Mr. Dickens bring you the firearm that he used to kill Mr. Montalvo?
No, sir. He said he dished out the window.
Okay, and you'd agree with me that you've not charged Chase Dickens with tampering with evidence. Is that correct?
No, sir.
Okay, and you'd agree with me that Mr. Dickens accompanied Mr. Talent for what would have been a drug transaction. Is that correct?
Not to his knowledge from his statements.
And you'd agree with me that you've not charged Chase Dickens with felony murder. Is that correct?
Yes, sir, because he was unaware of any felony that was going to persist as far as drugs.
And that's based solely off of what he told you. Is that correct?
And any text or anything that I've witnessed.
Okay. And when did Mr. Dickens come give you these statements? How far after this incident did he do that?
Oh, I'll give you the exact time. So the incident occurred around 11:39. What time he come to headquarters? We interviewed him at 4. I would say he maybe arrived at like 3-ish. Oh no, that's Mr. Queen. Hold on, stand by. Queen got there at 4. He arrived while we were still inventorying the vehicles downstairs. So hold on 1 second. Let me see what time it says on the interview sheet. And on my Miranda form, it says 7:20. So we didn't even get to 7:20 as far as the interview goes.
And it's at 7:20 the morning after, or
The morning after. So the incident happened on the 8th at around 11:39, 11:49. And we didn't get to interview him until 7:20.
and did Mr. Dickens bring you the clothes that he was wearing at the time that this incident occurred?
I'm unaware. He showed up or whatever he had on.
Okay. And he didn't bring you any other physical evidence or provide you with any physical evidence. Is that correct?
The only evidence I believe from the way he described the incident would happen would have been the gun. And like I told you, he discarded the gun.
Okay. Did he give you his cell phone or allow you to go through his cell phone?
He provided me with his cell phone, which search warrant was obtained for.
Okay. And have y'all executed a search warrant on his cell phone?
No, sir. It's still pending.
Okay. No further questions, Your Honor.
Okay, I do have 1 or 2 questions for the officer. So according to the probable cause warrant that you took out against Mr. Queen, it states here that Mr. Dickens stated that the passenger, Mr. Dickens stated that Mr. Talent exited their vehicle and got into the rear seat of the subject's SUV. Was it your understanding that was the Gold SUV?
Yes, ma'am.
And then it further states Mr. Dickens stated the passenger of the Gold SUV exited the front door and opened the rear passenger side door. Who would that be? What was your understanding of who that's
Reviewing the quick trip footage that I seen, it was a white male with a gray hoodie in it, and as well as described as Mr. Dickens. So that would be Mr. Queen, to the best of my ability to testify to.
And then it further states Mr. Dickens described the passenger who exited the vehicle as a white male wearing a gray hoodie with curly hair. And that's who you believe to be Mr. Queen?
Yes, sir. Yes, ma'am. He has curly hair. The hair he has today was similar to how it was that day that I interviewed him at headquarters.
Okay, so I guess I'm confused. So when he exited the front door, did he actually get back into the vehicle, but at the rear passenger side? I guess
on the rear passenger side, from the description that I received, it appeared that he would be standing up, opening the door and standing up, pointing the gun from the outside of the vehicle, not actually entering into the vehicle.
Okay, those are my questions. Okay, Attorney Hensinger, do you have any questions in response to my questions?
No, Judge.
Okay, Attorney Florio, do you have any questions in response to my questions?
No, Your Honor.
Okay. Is state rest, or do you have any other witnesses?
State rests, we're ready for argument.
Okay, Attorney Florio, do you have any witnesses for the
We do
defense?
not, Your Honor.
Okay, we're ready for argument. The state.
State waives opening.
Okay, Attorney Florio.
Judge, when I look at what the detective has testified to, and I think, well, what makes the most sense? What's the most logical? So if we take what Detective Montgomery testified to be true, and that's based largely off of messages and communications, Detective Montgomery has testified that the whole purpose of this encounter was because Mr. Montalvo was going to front drugs to Mr. Talent, meaning Mr. Montalvo was going to give drugs to Mr. Talent. So the idea that this was some sort of a robbery or some sort of we're going to get him, it doesn't make sense. What are we going to rob him of? He shows up with no drugs and no money because we're the ones that, according to the communications, Mr. Montalvo's the one that's going to show up with the drugs. The drugs in this case show up, according to the communications, with Montalvo. And Montalvo's going to give the drugs to Talent. What do we then know? We know two things occur. We know that Montalvo is shot 3 times in the back, and we know that Talent is shot 1 time face to face. Why is Montalvo shot 3 times in the back, and why is Talent shot 1 time face to face? And the only person who provides any sort of explanation for that is Dickens. And what Dickens tells is completely self-serving. If it were me, if I were Dickens, I'd say Keith shot him first. And why would I do that if I were Dickens? Because I just shot Montalvo 3 times in the back. I mean, I've got to say that Keith shot him first. Because if I don't say that Keith shot him first, then there's no reason under the sun why I shot Montalvo 3 times in the back. And so what you have is you have Dickens leaves the scene. Dickens gets rid of his gun. Dickens goes home. Dickens changes clothes. Dickens speaks with his parents. And then the next morning, Dickens shows up and says, hey, look, I need to tell y'all what happened, and gives a completely self-serving statement. And I would encourage Detective Montgomery to continue to review social media, to continue to determine during your investigation what Chase Dickens is posting on social media about this situation. And so what you have is you have a completely self-serving statement made by Chase Dickens, and Mr. Keith Queen being the butt of it. Hey, man, he shot my friend first. A friend, you remember what Dickens said. Talent is known to have a gun. Talent always has a gun. That's what Dickens said. Talent always has a gun. So what happens? You know, this 16-year-old shoots and kills a grown man who always has a gun? No. What happens is that it's a robbery because we've got the drugs. We're the ones that get set up. Talent test. I mean, that's what they're saying. They knew we were showing up with the dope. We're going to rob somebody when we're the only ones with dope? Who are we going to rob? The story that's told by this young man, Mr. Dickens, makes absolutely no sense. I think we showed up with the drugs. I think we were going to be the victim of the robbery. I think Montalvo shot 3 times in the back. And I think then at that point, Queen's acting in self-defense because Talent's a bad dude who's a drug dealer who's always got a gun. I think that's what happened. I think that's a lot more logical with the facts and explains it. And so, Judge, based off of what I believe is certainly the more logical explanation for what happened, I'd ask that this court dismiss these charges, especially in light of the fact that warrants could have been issued for Dickens for tampering with evidence. And if you take the arguments that the district attorney's office made in Mr. Stubbs's preliminary hearing about felony murder, if you take those arguments to be true, then there's absolutely no reason why this young man wasn't charged with felony murder as well. And I suspect he thought he was going to be charged with felony murder and thought, I'm going to get out ahead with the story because I got to, because I shot somebody 3 times in the back. Thank you, Your Honor.
Thank you. Attorney Hansinger?
Yes, Judge. Judge, I think it's important in this case to narrow our focus into what's in front of us. Currently, we are handling the preliminary hearing of Mr. Queen. We're not here to talk about any charges that haven't yet existed for Mr. Dickens. Certainly, you know, that is still an open door at this point. There's nothing preventing the state through either Clayton County Police Department nor my office from bringing out potential charges down the road, but that's not why we're here today. Fact of the matter is that Mr. Queen was with another individual and was going to meet up with the victim, Mr. Talent, to, at the very least, conduct a drug transaction. Mr. Queen is a minor who had a firearm, again, wasn't supposed to be having firearms. So assuming even that he knew that this was a drug transaction, he then would be culpable as a party to that felony murder, just like in the other case that we discussed earlier today. To go further, Detective Montgomery testified that his further investigation showed that Mr. Montero's Facebook conversations were that this was not merely a robbery, but a murder, that he was going to, I forget the wording that he used from that Facebook post, but it was something along the lines of that the purpose of this was to kill Mr. Talent. though Mr. Queen was not a party to that Facebook communication, certainly there could be the understanding that when they got into that vehicle, conversations likely occurred between Mr. Montero and Mr. Queen, which was the basis for why Mr. Queen even was, present with a firearm as a minor, going to either do a drug transaction or potentially even Mr. Montero advised him, what the true nature of this was, and that was a hit on Mr. Talon. So certainly there's enough probable cause at this point regarding the fact that he was a party to the murder of Mr. Talon, and then as a party to the felony that is going on, he is liable for the death of his co-defendant or co-conspirator at that point, Mr. Montero, as they are handling a felony. So again, it goes back to that, case where you go to rob an individual and your co-conspirator ends up getting killed. You're liable for their death just as much you are an innocent victim. Regarding the aggravated assault, there's probable cause to indicate that he shot at Mr. Dickens as he was driving away. That's what Mr. Dickens indicated, and that's what Detective Montgomery testified to, as well as firing at Mr. Talon. Who fired the fatal shot is at this point and ultimately irrelevant. Fact is that Mr. Queen had a firearm, and whether he shot and killed Mr. Talon, Mr. Talon, or whether it was Mr. Montero's gun that ultimately killed Mr. Talon, that's something that can be resolved once the GBI, figures out what the caliber of the firearm was that killed Mr. Talon. But certainly he is regardlessly liable for the death of Mr. Talon and ultimately Mr. Montero, because he was present with a firearm and was a knowing participant in that whole felony and scheme going on. Regarding the tampering with evidence, there's probable cause to indicate that knowing that a potentially 2 deaths, but at least 1 death had occurred with Mr. Montero, who he brought back to his mom's house. He then flees from the scene with the vehicle that has all of the evidence, from shell casings to presumably the firearms of not only Mr. Talon, but Mr. Montero and himself. That's 3 firearms, none of which have ever been recovered from that vehicle when they found it in Henry County. So there's certainly probable cause to indicate that at least as he's leaving Clayton County, there's firearms in that vehicle. And when he gets to Henry County, those firearms are no longer in that vehicle, as well with the understanding that once he gets to Henry County, he then attempts to tamper with the evidence there in terms of disposing of the shell casings and cleaning up the blood from the vehicle. So we ask that you bind over all charges against Mr. Queen, as there is probable cause to support all of them. Thank you.
Thank you. Based on the evidence presented by the parties today, I do find sufficient probable cause to bind over all charges for the defendant Keith Queen with respect to the charge of murder, aggravated assault, tampering with evidence, as well as the last count of murder. So that will be the order of the court today. That will conclude the hearing for Mr. Queen. And I do want to thank both parties for their presentation of their case. Thank you.
Your Honor, that concludes my business before the court today. May I be excused?
Yes. Thank
Thank you,
you.
Your Honor. Thank you, Mr. Hansinger.
Okay, and I believe deputies with the juvenile court, I think that concludes the calendar for you guys today.
All right, thank you, Judge.
Thank you for your cooperation.
Welcome.
Judge, the officer is logged on for Jesse Jordan. Their officer is also logged on for Armonte Johnson.
Okay, let's see who's ready to go first. Let's see. Let's do Jordan. I believe we mentioned, did you say Jordan?
Yep, Jordan was the one we had been talking about, the juvenile court.
So let's do Jordan. And then we'll go back to Johnson. Okay, Attorney Rogers, Deputy, will you bring forward defendant Jesse Lewis Jordan Jr.? Okay, I'm officially calling the state of Georgia versus Jesse Lewis Jordan Jr. for warrant number 2022 CW 55531 for the charge of aggravated assault by strangulation. Warrant number 2022 CW 55532 for the charge of battery family violence. And then the third charge of warrant number 2022 CW 55533 for the charge of theft by taking. Those are the charges pending against you today, Mr. Jordan. This is your preliminary hearing. The state will be represented by Attorney Evan Hensinger, and your attorney, Attorney Rogers, will be representing you via Zoom. At this time, is the state ready?
Yes, Judge, and the state calls Officer Evan Bowling.
Okay, if you would turn on your device, sir, please. Officer Bowling, can you hear us? Officer Bowling? Or do you have your cell phone number that you can reach him?
Yes, Judge, I'll give him a call.
Okay, thank you.
Judge, he did not answer my phone call. I've also sent him a text letting him know that we're doing his case. If he could turn on his audio and video. I don't know if he maybe just stepped away from his device.
Okay. Okay, well, let's go ahead then and move forward with, so we can keep it going. You said that Johnson is ready to go? I'm
Yes.
sorry.
And that officer, I believe, is Moto G Power.
Okay, so that's Attorney Pleasant case. Attorney Pleasant, are you ready to go on Johnson? Attorney Pleasant?
Yes, Judge.
Sorry, are you ready to go on Pleasant? We were gonna try to do Jordan, but the officer is I guess, has stepped away from his device.
Yes, I'm ready on Johnson.
Okay. Deputies, we apologize, Mr. Jordan. We're gonna do Johnson before and then we'll resume yours. We're just waiting on the officer. Thank you. Deputy, if you could bring for Armonte Johnson. Okay, Mr. Johnson, this is your preliminary hearing for today. I'm calling State of Georgia versus Armonte Johnson for warrant number 2022 WA 18877 for the charge of aggravated assault. We have a second charge for warrant number 2022 WA 18878 for the charge of firearm discharge near a highway. We have a third charge for warrant number 2022 WA 18879 for the charge of reckless conduct. We have a charge for warrant number 2022 WA 18880 for the charge of cruelty to children in the first degree. We have warrant number 2022WA18881 for the charge of possession of a firearm or weapon during a crime. The last charge we have is warrant number 2022WA18882, the charge of theft by receiving stolen property. Those are the charges pending against you. Is the state ready to pursue?
Yes, Judge. State's ready, and they call Officer Navarez.
Present.
Officer, can you raise your right hand? You swear affirm testimony you'll give in this matter pending before the court is truth, whole truth, and nothing but truth, so help you God.
I swear.
Can you introduce yourself?
Detective Narvaez with the Lovejoy Police Department.
Thank you, Detective. I'm sorry, Detective Narvaez. Sorry, I had your name wrong. What is your current duties with the Lovejoy Police Department?
Police officer up until January the 6th, where I was promoted to detective up until now.
Okay, so you were a detective on December 10th of 2022 when this incident occurred?
No, regular patrol officer
Okay, you're still on patrol.
back then.
Did you get called to a shooting or a person shot on Registry Boulevard?
That's affirmative. On December the 10th at approximately 22:04 hours.
Okay, were you the first responding officer, or did you come after somebody else that already came on scene?
My supervisor at the time, Sergeant JRC, will respond a couple minutes before my arrival.
Okay, what did you observe when you arrived?
When I arrived at the location that we were provided by dispatch, which upon investigating is going to be a secondary location, the victim's house, I observed multiple persons inside the house just yelling, screaming. I also observed a juvenile laying on the floor, screaming nonstop. I tried to make contact with him to get some information from him, but I wasn't able to due to his emotional state at the time. I was advised that he had an injury on his hand, and upon me checking on his injury, I observed it was a superficial injury at the time. It was later found out that he had a bullet fragment inside his right hand, which was later taken care of, and that's what
So
I.
there was I'm sorry, just so it's clear, there was a juvenile inside of the location who had ultimately a bullet fragment injury to his hand?
Yes, sir.
Okay. You can proceed from there. Did you speak with anybody else?
After I wasn't able to to get any information from the victim, which will be juvenile 1 in my report, I did make contact with one of the family members, which will be Miss Harvey Destiny, which identified herself as an auntie. And upon making contact with her, she basically told me that she was standing on the residence driveway, just watching the juveniles driving around the neighborhood, recording themselves. When they kept driving around the neighborhood, she lost sight of them because they were on the other side of the neighborhood when they hit the curb, when she heard some gunshots going off.
So you spoke with Miss, I believe you said Miss Harvey, is that correct?
Destiny Harvey.
And that
I'm
is
sorry,
the juvenile's aunt?
She identified herself at the time as the auntie, yeah.
Okay. And were there multiple juveniles on scene?
Yes, sir, there were around 4.
Okay. Do you recall which juvenile was the one who had the injury to their hand?
It will be Xavier.
Xavier Wise.
That's correct. Xavier Wise.
And so Xavier and 3 other juveniles were driving a car around the neighborhood.
That's correct.
Okay. And through your investigation, what did you learn led up to while they were driving the car? What did you learn happened?
Well, when I arrived at the location, before going inside the house, I observed there was a silver Chrysler 300 parked in front of the house, which was the vehicle they were driving around. I also observed the car had multiple bullet holes on the right side of the vehicle. After I made contact with Harvey, and after being unable to obtain any information from Xavier, I went to check on the car, and I observed there was a cell phone laying on the rear right side seat, which belonged to one of the juveniles, which was sitting on that same seat recording himself. I think it was on TikTok or something like that, while they were driving around. The cell phone, we noticed it was still recording. And upon getting consent from the cell phone owner, the juvenile and his parents, we checked the video recording, and we observed that we confirmed Destiny's version that they were driving around, recording themselves. And the juvenile that was holding the cell phone was sitting on the window, fixing his jacket hoodie, when upon passing one of the houses in the neighborhood, somebody was standing on the driveway, and you only see flashes going out. And then from there, they speed off and took off away from that location. You cannot see anything else in the video recording.
Okay. Through your investigation, were you able to determine where that residence was where the shooting occurred?
Yes, sir. Upon reviewing the video a couple of times, and since back then, most of the houses had Christmas decorations and lights, we compared the video to what we were observing while on site, and we were able to identify the house. And while walking around the neighborhood, we came across the house, which will be the primary incident location. And then we immediately found multiple spent shell casings, different calibers, laying around the driveway of that house, and on the grassy area between that house and the house next door.
Okay. Was that primary incident location, as you described it, was that 11688 Registry Boulevard?
That's correct.
Okay. And did you make contact with the occupant of that home?
I did, in fact, knock a couple of times on the front door. I made several attempts to try to make contact with anybody inside the house, but at that time, there was nobody inside, or at least nobody came to the front door, even though there was a vehicle on the driveway.
Okay. Did you determine who resided at that location?
We were unable to at the time.
Okay. So what ultimately led you to Mr. Johnson?
Okay, well, we were at the first house we arrived to, the victim's house. And while I was talking to Miss Destiny, one of the juveniles, well, the owner of the cell phone, told Sergeant RC, hey, that's them over there. Sergeant RC yelled at me, come on, he identified them, those are the suspects over there. Where I was standing in front of the house, if I look towards the street, I can only see fire engines and police vehicles in the front of the house, and I cannot see beyond that point. I went ahead, got in my patrol vehicle. Sergeant RC got in his patrol vehicle first than me. He took off one direction. I went the other direction. Probably, I don't know, a minute or less after that, I heard Sergeant RC making contact with the vehicle that Juvenile 2 in my report identified as the vehicle with the suspects. Sergeant RC made contact with them at the intersection. Let me see my notes over here really quick. I'm sorry, Registry Boulevard and Registry Place. That's the exact place where Sergeant RC intercepted the vehicle, which was a Honda Accord, the gold in color.
Okay, so when
and then
I'm sorry, when
Yeah.
the vehicle was pointed out to you by one of the juveniles, and you all made contact with the vehicle, who was occupying that vehicle?
There were 4 occupants in that vehicle at the time when we made contact with them.
Okay, who were the occupants? Or I should say, I guess, was Mr. Johnson, the defendant, one of the occupants?
Yes, sir.
Okay, what was his location inside the vehicle? Is he the driver, passenger?
Front side passenger.
Okay. Did you discover any evidence regarding Mr. Johnson and his involvement?
While I was standing on the rear left side of the vehicle, making sure the driver and the rear left passenger maintain their hands up, Sergeant RC was detaining the front passenger, which in that case will be Mr. Johnson. And once secured, he proceeded to check the area immediately around the front seat, and he found a 9mm Glock 17 gun laying right under the seat.
Okay,
The front
so a
passenger
handgun is located underneath the seat where Mr. Johnson was sitting.
That's correct.
Okay. And did you conduct any kind of a show up or line up with the juvenile victims?
I did not. That was made by CID Lieutenant Turnbull.
Okay.
That
To your knowledge, were the juveniles able to identify any of the suspects?
according to the knowledge obtained by Lieutenant Turnbull, yes, the 4 juvenile victims were able to identify 3 of the suspects in the
Okay.
car.
Was defendant Johnson identified by the juveniles?
Yes, sir.
Okay. And were you able, from the video that you watched, in that video, are you able to identify particular individuals in terms of shooters?
No, due to the fact that the vehicle was in movement, you can only see a silhouette of a person standing on the driveway.
Okay. Are you aware of where the defendant lives?
Yes,
What's the defendant's address? Is it that same instant location, or does he live at another address?
it's the same subdivision.
Same subdivision,
Mhm.
but not the instant location, 1111 688 Red Tree Boulevard?
Not that we were aware of at the time.
Okay. And both in that whole neighborhood, is that, to your knowledge, is that neighborhood within Clayton County?
Yes, sir, inside the city of Lovejoy.
Okay.
City.
And the front seat passenger who you stated was defendant Johnson, do you see that person present here today?
I haven't.
I'm sorry, I didn't understand your response.
I haven't. I don't have the option of looking at anybody here.
So you can't see anything but yourself, or can you see me when I talk?
I can only see yourself.
Okay, your phone doesn't allow you to change the view so that you can see all participants?
Oh, hold on. I was looking at the list of participants, but I don't see his name.
That wasn't my question, officer. My question was whether or not you can change the view on your phone in terms of just changing it so that you can see to a gallery view and see all participants of the video.
No, that's negative.
I'm sorry, I didn't hear your response.
I'm unable to now.
Okay. Judge, would it be possible for the jail to unmute themselves and one of the deputies make a statement so that that video will show up on the officer's screen?
This Deputy Taylor.
Officer
Officer
Never. You can mute now, jail. Thank you. I think we just lost the officer. Officer, were you able to see the video when the jail was speaking?
Oh, sir. Just heard noise. No.
Officer, are you having problems with your phone?
No, I can see you and hear you well, but nothing else.
You appear to keep freezing, so I'm not catching all what you're saying.
But I wasn't able to see any images regarding the offender.
Can you see me when I talk?
Yes, sir, I can see you.
Jill, can we try this one more time if one of the deputies could unmute?
Okay.
Can you see the jail now?
Yes, sir. Yes, sir.
Thank you, Jill. You can mute. Officer Navarez, the individual who was present at for the Zoom screen for Clayton County Jail, do you recognize that individual?
Yes, sir, I do.
We recognize that individual as.
Mr. Johnson?
Okay. Let the record reflect that the officer has identified defendant Johnson. State has no further questions at this time.
May I proceed? Judge, you're on mute.
Yes, you can proceed. It looks like your client had a question. I'm not certain if you want to get into a
Can you put
breakout
me in
room.
with the jail quick, briefly?
Yes,
Thank you.
so it'll be breakout room number 1.
Okay. Oh, okay.
It looks like you're already in room 1. Can you, okay, thank you. Brief recess. Attorney Hansinger, can you mind if you contact Officer Boland again and make sure he's ready to go for the next case?
Yes, Judge. He texted me while we were doing this and indicated that he's back at his device.
Okay, thank you.
Thank you for the time, Your Honor.
Okay, you ready to proceed?
I am.
Okay, your witness.
So Officer Navarez, you indicated that you reviewed a video in this case, correct? Of testimony on direct.
Correct.
And what's the length of the video?
I don't know the exact amount of time, but it's not that long.
Okay. And what's the length of the portion that shows what you're alleging is a shooting?
A second or two.
And in the video, you can only see one silhouette?
Yes, yes, ma'am.
How many shell casings did you say were recovered?
There were approximately more than 40 or 50 shell cases.
And what type of weapons were recovered?
Multiple from 9mm to .223.
A 9mm and a 223?
The range from
But
from
those shell
one-
casings consistent with those type of weapons?
Yes, ma'am. Multiple caliber.
Okay. You don't recall all of the calibers of weapons?
I'm sorry?
You do not recall all of the calibers of the weapons that you're alleging were involved?
Yeah, I remember 9mm, 40mm, .223. Those are the ones I remember.
And the weapon that you're alleging was under their passenger seat, was it visible upon entry of the vehicle?
I did not observe the gun. It was Sergeant RC, the one who observed the gun,
And what did Sergeant RC advise with regards to the gun?
that it was underneath the front passenger seat close to the door.
Did he indicate he was able to see the weapon as soon as he went into the car?
He indicated that upon he flashing his flashlight, he was able to see it.
And what time of day are you alleging this event to have occurred?
During the night, 22:04. That's when we were dispatched to. The time we were dispatched.
Are you aware of any history between Armani Johnson and the alleged victims in this case?
No, ma'am.
So in the course of your investigation, you didn't discover any previous situations, any bad blood, anything with regards to the 4 alleged victims and my client?
No, ma'am. Not at the time. Like I said before, nobody was providing any information at all when I arrived at the incident location. Nobody was providing any information other than they were shot at.
And specifically, what are you alleging Mr. Armani Johnson to have done in this instance?
Can you repeat your question again?
Why'd you arrest him?
Oh, due to the fact that one of the juveniles that were inside the car that was shot at, identified them as being the suspect that shot at them.
How many people did the juvenile say shot at them?
They didn't say a specific amount.
And the video only shows one silhouette.
In the video where you see the juvenile recording himself passing through that specific house, yes, you can see one silhouette on that video frame.
Did anybody, any of the alleged victims state how many people they thought were shooting at them?
No.
Were you able to observe any video from any residents in that home?
We tried to make
I mean,
contact
in that area.
in the area immediately where the shooting took place at. Yes, we
Yeah.
tried to make contact with the neighbors around that had cameras pointing at that direction, but at that time they were not at home or they were out of town.
Anyone follow up with the neighbors?
Yes, one of the cameras was not working. One of the other houses still nobody has arrived to their house. Come back.
So is it your testimony that the only video you have in this instance is the one that was taken by one of the alleged victims?
That's correct.
And did you inquire of the alleged victims whether or not any of them possessed any handguns?
At the time, no.
Any indication that any of the alleged victims in this case fired upon Mr. Armani or any other individual?
No.
at the incident location. Okay. Did you perform any handgun residue tests in this case?
No,
How many weapons in total did you recover?
just one, the one under Mr. Johnson's seat.
And did you speak to Mr. Johnson with regards to these allegations?
Yes, I proceeded to Mirandize him, read him his Miranda rights in order to ask him some questions. At which time he only admitted that he bought the gun from the streets. I'm quoting him in briefing, and that he was only admitting on that because he didn't want it to get in trouble any other person in the car.
You made no statements with regards to the alleged incident,
No,
the actual
refused.
shooting. That's all I have, Your Honor.
Okay, any redirect for the state?
Briefly, Judge. Officer, the handgun that the defendant indicated he had bought, was it, did it come back as stolen?
Objection to leading, and it's beyond the scope of crime.
Judge, it's not a leading question because did is open to, he can either confirm or deny that. I'm not suggesting that it did come back as stolen. That, and regarding scope of the cross, Attorney Pleasant is the one who asked about the firearm, and it came out that the firearm was purchased. So it certainly is within the realm of the scope of that cross as to whether or not that firearm was lawfully purchased or if it was indicated to be stolen.
Overruled. You can answer, officer.
Officer, the firearm that the defendant indicated he had purchased, did it come back as stolen?
Yes, sir. It came back stolen out of DeKalb County.
Okay, and there was some questions about the shell casings and them being of multiple calibers. Were those shell casings consistent with a single shooter or multiple shooters?
Multiple shooters.
No further questions at this time, Judge.
Okay, do you have any other witnesses for the state?
State rests.
Okay, Attorney Pleasant, you have any witnesses?
No witnesses, Your Honor.
Okay, we're ready for arguments. The
State
state.
reopening.
Okay, Attorney Pleasant.
One moment, Your Honor. Your Honor, the testimony is essentially that there's a video that shows a silhouette, but there is nothing that identifies Mr. Johnson as being the silhouette, the resident. There's no amount of, no number given for by any of the alleged victims, people who actually participated in this alleged incident. There was no handgun residue test performed on my client to confirm that he actually fired the weapon that they're alleging that he was in possession of. So based upon that, I would ask that the charges against Mr. Johnson be dismissed.
Okay, and the state?
Yes, Judge. Judge, we ask that you bind over all charges against Mr. Johnson as probable cause does exist. The testimony today has been that Mr. Johnson was located by officers with a handgun underneath of his seat while he was inside of a vehicle. That vehicle was identified by one of the juvenile victims in this case as being involved in this shooting. Further, one of those juveniles indicated that the defendant was one of the individuals who had shot at their vehicle. there were multiple calibers of shell casings located outside of the incident location. The detective or officer testified that that would be consistent with multiple shooters. So although there's only one silhouette seen on video, the physical evidence supports that there were multiple shooters, as well as the juvenile indicating that the defendant was one of the shooters on scene. So that supports the aggravated assault charge, reckless conduct. There also was the testimony of the officer that when he arrived on scene, there was a juvenile who had a injury to his hand, a bullet fragment. That would be consistent with the cruelty to children. And so all charges, Judge, in this case, there has been probable cause supporting it. And we ask that you bind over all charges.
Okay. Based upon the evidence presented by the parties, I do find sufficient probable cause to bind over all charges with respect to Armonte Johnson to the Superior Court of Clayton County, that specifically being the charge of aggravated assault, firearm discharge near a highway, reckless conduct, cruelty to children in the first degree, possession of a firearm and or weapon during a crime, as well as theft by receiving stolen property. So that is the order of the court today. That will conclude your preliminary hearing, Mr. Johnson. Thank you. Thank both parties for the presentation of the case. Thank you. So I believe the next case on the calendar we have is Jordan, correct?
Yes, Judge.
Jordan is ready to go.
Yes,
Attorney,
Judge. The officer is here.
okay, Attorney Rogers.
Yes, ma'am.
Okay, for the record, I'm officially calling, I'm sorry, Deputy, can you bring forward, oh, there we are. Is that Mr. Jordan? Are you Mr. Jordan? Sir?
Yes, ma'am.
Okay, thank you. Okay, thank you. Mr. Jordan, this is your preliminary hearing. I'm officially calling the state of Georgia versus Jesse Lewis Jordan Jr. for warrant number 2022 CW 55531 for the charge of aggravated assault by strangulation. A second charge, warrant number 2022 CW 55532 for the charge of battery family violence. Third charge, warrant number 2022 CW 55533 for the charge of theft by taken. Those are the charges pending against you. Is the state ready to proceed with their first witness?
Yes, Judge, and the state calls Officer Evan Bowling.
Okay.
Officer Bowling, can you raise your right hand? Do you swear affirm testimony you'll give in this matter pending before the court, truth, the whole truth, nothing but truth, so help you God?
I do.
Lower your hand. Can you introduce yourself to the court?
My name is Officer Bowling, and I work with Clayton County Police Department.
Officer Bowling, were you on patrol on December 11th of last year?
Yes, I was.
Did you respond to 5870 Sheldon Court?
Yes, I did.
Your knowledge, is that within Clayton County?
Yes, sir, it is.
When you arrived on scene, whom did you speak with?
I spoke with the victim, Yolanda. I'm sorry, Yolanda Womble.
And what did Miss Womble advise?
Miss Womble advised that she and Mr. Jordan, who were, she said they were friends and they have previously lived together. She gave Mr. Jordan and one of his friends a ride over to Miss Womble's friend's house, Miss Goolsby. Once they were at the house, she stated that Mr. Jordan became very intoxicated and I think wanted to take a nap in someone's bed, and they got into an argument about that, I guess, move being inappropriate. At that time, Mr. Jordan got very verbally upset and then became physical, Miss Womble, and started hit her in their chest. He then put his hands around her throat and started choking her. Miss Womble stated that she felt that Mr. Jordan was trying to kill her and that she was unable to breathe. She said that she started trying to hit his hands away or grab his hands off of them. His hands off of her throat. Which point he ended up scratching one of her hands when he was grabbing at them. He then put his hand across Miss Womble's mouth and ended up cutting her cheek. So I was able to observe a cut on Miss Womble's cheek, as well as a cut on her hand, and I could see a red mark on I want to say it was the right side of her neck, where she alleged that Mr. Jordan had choked her. She said that after Mr. Jordan was done getting physical with her, he then grabbed her purse, which had her ID, EBT card, couple other items, as well as her car keys, and left the house and got in her car and drove away. Ms. Womble did say that Mr. Jordan, she said that the car was in her name. She has let Mr. Jordan drive the car in the past before, and his name was in on the insurance. She wasn't unable to provide any sort of proof of ownership of the vehicle, but said that whenever he gets mad in the past, he takes her vehicle. So at this point, due to her visible injuries, I took a warrant out on Mr. Jordan. And then he came back to the same residence the next day, 2 different times, and I was able to arrest him on the second time. And he had driven her car back to the residence and had parked it just around the corner. So we were able to get her car back as well.
Okay. Let me break down kind of everything that happened here, just so it's clear for the record. When you spoke to Miss Womble, she indicated that all of this kind of happened at her friend's house. That's Miss Goolsby, I think you indicated.
Correct.
Do you know where Miss Goolsby's location is, or where her residence is?
That's the incident that I showed up to.
Okay,
That's
so Miss
the Sheldon Court. That's her house, Miss Goolsby's house.
Okay, so Miss Womble was at Miss Goolsby's house still.
Correct.
Okay. And you observed injuries to Miss Womble?
Yes, sir.
I think you indicated that there was you observed scratches to her face.
Yes, sir. She had a cut with dried blood on one of her cheeks.
Okay. And did you also observe any injuries to her neck?
Yes, she had a red mark. I believe it was on the right side of her neck, where she said where she had been strangled.
Okay. So her injuries were consistent with the strangulation?
Yes, sir. There was a visible red.
Yeah, I'm going to object. For one, it's leading. For two, it calls for speculation. There have been any kind of testimony about any kind of medical training on the officer's behalf, any forensic training, or any basis for him to speculate on that. So I would object for both reasons.
Okay. Attorney Hanson, you have a response to that?
Judge, the observations of the officer are within his scope of, being a layperson in terms of the weight that may go to. That's what the credentials would go to, but certainly he can offer his lay opinion as to whether or not that's consistent with being strangled.
Yeah,
Okay, go ahead, Attorney Rogers.
I would stand on that objection. That's still an opinion about whether or not observations of the human body are consistent and how they would be applied and how they would have been received. He's been asked to speculate about it. There's been no testimony about any basis for him to make opinion statements. This is about factual testimony. That's all that's.
I agree. I'm going to sustain it. He can testify to what he observed in terms of the visible injuries.
Thank you, Judge. And Officer Bowling, the items that were taken out of her purse, were those ever recovered?
I do not believe she found those, at least while I was on scene. She didn't find those in the car when she got the car back.
Is that the basis of the theft by taking charge?
Yes, sir.
And the victim, Miss Womble and Mr. Jordan. Do they share any children, or what? Do they have any familiar relationship? Did they reside together, anything like that?
They did used to, per Miss Womble, they used to live together.
Okay, so they previously resided together?
Mhm.
Okay. When you responded the next day and arrested the defendant, is that correct?
Yes, sir.
Do you see the individual that you arrested on that date present here today?
Yes, sir, I do.
You identify them by an article of clothing and what their Zoom video says?
It's in the Clayton County Zoom link, and he's wearing an orange top with a brick or stone background.
Let the record reflect that the officer has identified the defendant. No further questions at this time.
Okay, Attorney Rogers, your witness.
Thank you. Officer Bowling, you're the lead officer on this case?
Yes, sir.
And as far as the day when you responded to the location, are you the only officer that responded, or were there other officers?
There was a second officer there.
And correct me if I'm wrong, but the incident location, you said is, I believe it says Miss Goolsby's residence, is that correct?
Yes, sir.
And was Ms. Goolsby present at the location when the alleged events were supposed to have occurred?
Yes, sir. She was present at the location. She saw Mr. Jones come in, but she said she did not observe the actual incident take place.
Do you know why in particular, like as far as where she was or what prevented her from observing?
I guess she was just in another room.
Let me ask this: if I understood it correctly, Ms. Goolsby is Ms. Womble's friend. Is that
Yes,
correct?
Yes, sir.
Do you know why they were going to the location?
I'm guessing just to hang out or something, a social engagement.
And the location that we're talking about, do you know how approximately how big of a house this is?
I mean, square mileage, I couldn't say. It's a
1 story, 2 story?
yeah, it's a 2-story.
So, and so does Ms. Goolsby say she hears anything consistent as far as like a commotion or a ruckus or anything?
I do not recall if she said she heard anything or not.
And as far as I know, there was also at least one other person, I think you said Mr. Jordan's friend went with.
That's correct.
Did anybody ever speak to that person?
He was not on scene when we were there, and nobody knew his name, phone number, anything like that.
And was there anybody else there at the location other than the 4 people that we've accounted for so far? Goolsby, Jordan,
Not to
Womble.
my knowledge.
As far as you know, is there any sort of video or anything of the incident?
No, sir.
And the incident started because, and correct me if I'm wrong, because Ms. Womble took issue with Mr. Jordan's desire to take a nap in the location.
That's correct.
Did she say whether or not she ever tried to physically stop him from moving around in the location?
She did not say.
And at the time, I know there was mention of Mr. Jordan possibly being intoxicated. Is he supposed to have been the only person drinking, or was Ms. Womble drinking? Were other people drinking?
I'm not 100% sure if other people were drinking. It's very much a possibility.
Okay. But you spoke with Ms. Womble directly?
Yes, sir.
Did you observe any kind of indication that she had been drinking possibly?
She possibly could have. She didn't come off as intoxicated.
And have you ever spoken with Mr. Jordan about the situation?
I didn't ask him, I didn't Mirandize him or ask him direct questions about it when he was taken into custody.
Okay. Let me broaden the question a little bit then. Did you have any sort of conversation with Mr. Jordan about the situation?
What questions I did ask him, like his social security number, so I could verify, verify his identity. He was in a very emotionally upset state and was not coherent in answering any questions.
And just now to tighten it up, I know I broadened it previously. Now I'm gonna try to tighten it up a little bit. Are you saying that all you asked him about would have been like general booking, biographical information? Is that what we're saying right now?
Yes, sir.
And when you spoke with, we'll start with Ms. Womble, is that recorded?
Yes, sir, my body cam would have been on.
And when you spoke with Mr. Jordan, would that have been recorded also?
Yes, sir.
So, and at this point, the charges are based strictly on Ms. Womble's account of events to you.
Yes, sir. Her account and her visible injuries.
Right. And let me just kind of tighten it up. I want to make sure we're being clear. What I'm asking is, obviously, I understand you're saying you observed injuries, but the only explanation you have for how those injuries occurred is her account. Is that correct?
That's correct.
No further questions.
Okay, any redirect from the state?
No, Judge, state rests.
Okay. State has any other witnesses?
No, Judge.
Attorney Rogers, do you have any witnesses?
No, ma'am. Yeah, just possibly argument if I could have a moment to look over the charges.
Okay. Assuming the state is waiving, correct?
Judge, state waives opening.
Okay, thank you.
Yeah, I guess I would make a general argument as it relates to the aggravated assault and the battery family violence. I guess it's probably not applicable to the theft by taking allegation. I will say that as it relates to the aggravated assault and the battery family violence, the determination of who the aggressor is, I would say at least it's unsupported by any other evidence other than the version given by Ms. Womble. And I understand that, that's a lot of the time that's enough, but the reason I call attention to that is just because it sounds like there was at least one other person who's at this residence who seems like if somebody came to hang out and all this commotion is going on, if you didn't see it, you at least may have heard something or come to the scene, especially if this is your friend who's come to see you and they don't have anything to say about it to corroborate it. And it started because Ms. Womble took issue with what Mr. Jordan wanted to do. Like, this was not an issue that, Mr. Jordan brought to Ms. Womble, even on her version. So between those two things, the fact that her friend is not co-signing her version of events, and it starts from Ms. Womble trying to stop Mr. Jordan from essentially laying down or taking a nap, not doing something objectionable, or at least certainly not criminal or anything like that. I would say it's a little premature to be charging him with those kinds of charges. So for those reasons, I would ask that the ag assault and battery family violence be dismissed for lack of probable cause.
Okay. The state?
Yes, Judge. Regarding the aggravated assault and battery family violence, there is probable cause to bind over those charges through the uncontradicted testimony of the victim, who told Officer Bowling that the defendant placed his hands around her neck and was strangling her to the point where she felt like she was going to die. Officer Bowling then observed injuries on her neck, which combined with that testimony provide probable cause as to the aggravated assault. Regarding the battery family violence, there was also the injuries observed by Officer Bowling, which combined with the victim's testimony provide probable cause for that charge. Regarding any potential primary aggressor, other than Attorney Rogers' speculation as to why other witnesses did not observe anything, there has been no testimony or other evidence presented that Ms. Womble was the primary aggressor. Her uncontradicted story was that the defendant was intoxicated and was attacking her. And then regarding the theft by taking, there is probable cause in the items that were stolen out of Ms. Womble's purse but never recovered at that time. So the state asks that Your Honor bind over all three charges, as there is probable cause supporting these charges.
Okay, thank you. Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over all three charges against Mr. Jordan to the Superior Court of Clayton County, specifically for the charge of aggravated assault by strangulation, the charge of battery family violence, as well as the theft by taking charge. That is the order of the court today, and that will conclude your preliminary hearing, Mr. Jordan. Thank you.